I just want to take a brief call to go into some more detail on the concerns that were adverted to by my colleague Leanne Dalzell earlier. And just before I do so, I will just remind the Committee of the Whole that this has been a process. We had the two original pieces of legislation, the financial services legislation, the financial providers registration legislation, enacted by the House in 2008. That was a process beset by deadlines, as was this legislation. And it would be a shame if, having put all the work that all parties and all members, particularly on the Commerce Committee, have put into this legislation, we were to fail to get it right at the last hurdle, as it were. So I do want to ask the Minister and the Chair, I see it's the Honourable Pansy Wong, whether she would be able to address the two issues that have been raised with a number of parliamentarians in an email from Ray Neild. Now, Ray Neild has sent this email to Simon Power, Chris Finlayson, Heather Roy, Leanne Dalzell, myself and John Boscawen. We've made a copy available to the National Party backbenchers who serve on the Commerce Committee and to the officials so that they can be clear about the concern. I do just want to say, before I address the two issues, Ray Neild has a very successful legal practice in this area, and she has submitted to the committee at each stage of the legislation, and I think we've found her submissions helpful and found that they've had force. So, as I say, if she's raising a concern at this stage, I do think this is the last opportunity that we have to address it without having to come up with specific amending legislation later in the piece. I'll certainly signal on behalf of the Labor Party that if the government need to take a moment to address the issue, if there's a need to do some last-minute drafting, we certainly won't put any obstacles in the way of that course being adopted or object to any leave application for that purpose. But, sir, the two concerns are that the Act, as reported back from the committee, may apply much more widely than intended, that instead of being restricted to those industries just contemplated by the FATF requirements, we may have gone more widely than we intended without having consulted with the industry properly because of the timeframes that I referred to earlier. There was some mention of this in the submissions to the Select Committee, and the Select Committee did at the time say to the submitters who raised this point, we certainly don't intend to go more widely than we need to, and if we have done that inadvertently, I do think we need to address it. Now, the remaining specific issue in this point is that despite the broad coverage of the two pieces of legislation, inclusion within the regime is by regulating out, not by regulating in. So there is still a degree of commercial uncertainty for those businesses, arguably, which may have been incorporated. The examples in the message that we have are retailers with gift cards, prepaid mobile phones and mobile phone billing services, taxi billing services and other categories of financial services. And obviously it wasn't intended to embrace that category of industry. They'd be surprised to be included in this legislation, and there's no obvious public policy benefit in so including them. So while it appears that there's now provision to make regulations to detach registration from compulsory dispute resolution scheme membership, that's clause 33A, and for completely exempting services or classes of service, clause 37B for registration and clause 79 for the disputes resolution scheme membership, and for dividing into separate classes, clause 37B for registration, these won't in themselves provide necessarily for trader certainty. And traders caught in the broad definitions of the legislation are included unless exempted, and they're only exempted if they're not covered by the FATF as far as registration is concerned, and only if the Minister is satisfied that the cost of compliance is unreasonable or not justified by compliance. So what we need to hear from the Minister in the Chair is whether or not we have inadvertently caught this broad group of traders by the Act. Mr. Chairman, Thank you, Mr Chairman, because if we have, most won't know it. If they don't know it, they won't know they need to apply for an exemption, and the Minister then won't be able to say, obviously in those circumstances, whether or not it's too costly for them to comply. So the second concern that's been raised, and I would be grateful, as I'm sure would the rest of the House, if the Minister could address this as well, is the issue raised by clause 49D of the bill. Under this provision relating to essentially the binding nature of rulings in the dispute resolution scheme, a complainant can apply to the district court or a district court for a review of any final settlement. The dispute resolution service can apply for such a review, but there's no provision for the respondent financial services provider to apply for a review. So although the district court in question could amend a manifestly unreasonable provision, it could only do that on the application of the complainant or the provider of the dispute resolution scheme. And I think it is correct to point out that, at least on its face, that is a breach of the New Zealand Bill of Rights Act, particularly section 27, guaranteeing access to justice to every person including obviously legal as well as natural persons. And the other issue, sir, that's worth adverting to is obviously if that is a breach, given that it's come in on the report back from a select committee, it won't have had a chance to be vetted by the Crown Law Office and be the subject of a report from the Attorney General as to inconsistency. And then if the respondent doesn't carry out a non-pecuniary order from the dispute resolution system, it's committing a criminal offence, incurring a fine of up to $200,000. So I think this shows just how serious a potential breach this is. I think if the committee had been confronted with this point fairly and squarely, it would have asked the officials to suggest an amendment and strongly urged the House to rectify the apparent error so that all parties to a disputed resolution order could actually go on to a district court and have an error or an alleged error heard and, if proven, rectified. So those are the 2 points that would be, I think, helpful to hear from Pansy Wong on.
The Honourable Pansy Wong.
Well, Mr Chairman,